Michael Gellert, a local attorney. What you're about to watch is jury review. Jury review is usually held a few days before jury selection and is the last opportunity for the court to determine which cases will be tried in the following week. And it's also the last opportunity for defense and the state to possibly come to an arrangement to where trial can be avoided and a plea bargain arranged. It's also the last opportunity where state may choose to drop or change some of the charges. Also
just remind everyone, if you're going to have a continuance and you don't need your client here, please let them know sooner than later, because they've been transporting folks over and then some continued, just unnecessary. So we just be mindful of that. We've got a couple of attorneys that will be later because Judge Wells trumps everyone. Mr. Notes isn't here yet. And I believe my policy is 3 business days before continuance. Okay. Remind me, whatever trials we set today, remind me to ask how many we want on the conhiring. Mr. Durrell. Morning, sir. Happy Thursday.
Yes, Your Honor. Happy Thursday.
Thank you.
Your Honor, I have Mr. Michael Porter. He's an inmate. This was a late addition for entry of a plea, Your Honor. I've been over it with him, but he was not able to sign it. We just got this worked out the other day. So.
And you were just added, appointed, or appeared?
Yes, Your Honor.
Okay.
And Your Honor, while we're waiting on Mr. Porter, I will inform the court, it's just he's going to be pleading no contest to the violation of probation. It'll be reinstated with an additional 24 hours of community service. The state has no objection to allowing Mr. Porter to buy those out and complete all outstanding terms and conditions.
Okay, thank you.
And Judge, I will provide this worksheet.
Thank you, sir. Hello, Mr. Porter. Mr. Porter, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Mr. Drell's asking you if you understand the plea agreement, if you want to sign that.
I do. If I may
Mr.
approach
Drell,
her.
what would be the adjudication?
You know, I believe it was a withhold.
Okay. So, Mr. Porter, here's what please, Mr. Drell, if you want to.
Thank you.
Mr. Drell told me before you came out what's in the plea agreement. He said that it would be a withhold of adjudication. Your current supervision would be reinstated and modified so that you'd have to perform an additional 24 hours of community service work, but you could buy that out. There would be a $100 cost of prosecution. Is that what you wish to do?
Yes, sir.
Have any questions for me or Mr. Durrell of the state?
Do not.
Okay, Mr. Porter, I do accept your plea. Adjudication is withheld. Your current supervision is reinstated and modified to add 24 hours of community service work. You can buy that out. You'll need to pay the $100 cost of prosecution. Thank you, sir. Good luck to you.
Thank you, Your Honor. I believe that's all I have. If I may be excused.
Yes, sir. Thank you, Mr. Durrell.
Thank you.
Ms. Merrifield. See Ms. Merrifield. Mr. Shaw.
Good morning, Judge.
Good morning, sir.
Tim Shaw, covering for Mike Flowers. Case is Michael Mitchell McGee, Mulholland, 22 CF 1791. There was I think Mr. Flowers had filed a stipulated motion to continue maybe yesterday or the day before, indicating the alleged victim in this case was unable to be located. Apparently he showed up after court on Monday. Is that accurate?
Yes.
Okay.
Oh, sorry, Your Honor. So I spoke with Judge Flowers. So we had an instance in this case where we had set depositions. There was a victim and 2 witnesses. The law enforcement officer showed up. The victim never did. I had no contact at that point, and so that was when Mr. Flowers came, and I think he was under the impression that on Monday, if we hadn't heard from him we would dismiss it. I like to give until jury trial review just because it gives us the most amount of time. On Tuesday, I got up with the victim. He is going to proceed forward. He provided me with a new updated address, and he's also going to be helping to get the addresses for at least one of the witnesses. I already provided the updated address and amended discovery for the victim in particular. I believe, in speaking with Mr. Flowers, that he does want to be able to depose that victim. As I understand it, the reason why we filed the motion to continue, I told him that it would be, not within your window, and that we understood that. But with Mr. Flowers not being here, we just wanted to have something to show that him and I had discussed this, and so I think that's the reason why we're requesting the continuance, to be able to set those depositions for that for the next cycle, and then have this trial next cycle, or be resolved before then.
Mr. Mulcahy, Mulholland, do you agree to the continuance?
Yes, Your Honor.
Okay. I'll see you back here on July 10th at 9 o'clock. Okay. Thank you, sir. Thank you.
Thank you, Judge. That's all I had.
Thank you, Mr. Shaw. Mr. Gates. Mr. Gates sitting in the back of the courtroom. That's unusual.
Dr. Bob, you proceed. Good morning, Your Honor.
Yes, sir.
Your Honor, this is Donna Lambert. We'd advised the court earlier this week that this was going to be a PTI. We have not received the actual paperwork yet, so I think it would be appropriate to get us a control date, and then once you sign it and if she's accepted into the program, then it would just fall off the control date.
Ms. Lambert, then if the paperwork's not filled out for PTI and you haven't been accepted into that, I'll see you July 10th at 9 o'clock. Okay.
Thank you, Judge.
Thank you, Judge.
Also, I have a motion to terminate probation that's set for this afternoon. I talked with Mr.
Before we
Gomez.
make it that, what about De La Paz?
That should have already been continued, Judge. There is a companion case, and I had actually, the court had signed an order, I think, about a week ago, continuing both those cases to July 10th.
Okay. State you
I was under that impression as well, Your Honor.
Okay, so, Madam Clerk, we'll just note that's continued. Good. Yes, sir. Somebody asking. Something's this afternoon?
It is.
Thank you.
And Mr. Gomez is...
I reviewed the motion, Your Honor, and I would have no objection to the early term of probation.
Okay, so this is on McAfee
It is.
in 17 CF 183, 17 CF 3378, 18 CF 204, and 20 CF 2436.
Yes, sir.
Mr. McAfee's supervision is terminated.
Thank you, Judge. I've got a Zoom hearing this afternoon. I'll see you at 2:30.
Okay, good. Thank you, Mr. Gates. Ms. Jacob?
Good morning, Judge. The first I have on your docket this morning is Miguel de la Rosa. I did file the motion to dismiss as requested by the court, and I have a copy if the court has not seen it yet. However, with all due candor to the court, I have received the download for the digital discovery as well as the paper discovery packet. However, I still don't have a score sheet or an offer. Of course, the state is not required to make an offer, but at least a score sheet would be pertinent so that I could at least give my client some meaningful advice as to where his case could be going and what he could be looking at. So I'm just renewing my motion to dismiss the case at this point, basically for the state's failure to comply with their initial discovery obligations as well as the court's order requiring that discovery be provided to me by the 12th by 5 p.m., and it was not.
The state?
Your Honor, we did get all the discovery that we do have in our possession to the defendant. In this scenario, I think sanctions of dismissing the entire case would be, it would do more harm than good. It would be overreaching. In this scenario, the defendant has not been incarcerated. I understand that it is a little bit, it's very inconvenient. I'm not dismissing that, to be able to have to come into court and continue to get the case settled or continued and not have the discovery. However, I did provide the discovery. There is all the digital discovery in there. I will make sure that there is a score sheet that gets over there. I will say candidly, we have been in the process of moving almost all of our paper files to electronic from paperless. I think that's part of the reason why some of the things are in the paper file, but they're not in stack. Some things are in stack, but not in the paper file. I do sincerely apologize, but the state feels as though a motion to dismiss in this case would be too harsh of a sanction. We have provided all the discovery. The defendant has not been, left from being incarcerated or anything like that. I understand that, there was extra time added because of this. However, the state feels as though a motion to dismiss would be too harsh in this scenario, and we would request, a denial of the motion to dismiss and to allow us to proceed forward and try to resolve this case.
Mr. Gomez, do you have a score sheet here today?
I do.
You want to provide that?
Yes.
To Mr. Ms. Jacob, what does it show as far as, is there a minimum?
Your Honor, there's literally nothing on the score sheet other than this one charge. So he has no priors, and it would show 16 points.
Okay, thank you. Respectfully, the motion to dismiss is denied. I don't know what other sanction. I agree it's too harsh a sanction, but I don't know what lesser sanction since you're court appointed there is.
Yes, sir.
But I appreciate it. The court's here to help. I wish I could do more within that realm. I just don't know what to do at this point.
And with all candor, I expected the court to deny the motion, but I didn't want to not file it when the court had instructed me to do so.
And absolutely, yes, ma'am. Thank you. So it's continued until July 10th at 9.
Thank you, Your Honor.
Thank you.
And just for the record, the court had waived Mr. De La Rosa's presence today. Your Honor, also Charles Stovall in 22 CF 2612. I have not seen Mr. Stovall this morning. I do know that he lives in Bay County, so if I could just pass him for a few minutes.
Is he on the docket? I didn't see him.
He is, Your Honor. I have him as number 14 on my docket. I don't know if that could be very off, though.
Yes, ma'am. Good. Thank you. Okay, so we're passing. Yes, ma'am.
Thank you, Your Honor.
Thank you. Mr. Madden, you ready?
Yes, Your Honor.
Good morning, sir.
Good morning, Judge. John Madden here on behalf of Preston Nelson, who is present. This is case number 22 CF 2742. Your Honor, we have reached an agreement in this case with the state. Mr. Allison is going to be pleading no contest as charged. The terms are going to be a withhold of adjudication, 3 years probation, fines and court costs $967, $100 cost of prosecution. He will complete an anger management course, which can be done online. He will complete a psychological evaluation. He will have no contact with Joseph Coleman. He will maintain employment, and he may apply for early termination of probation after 18 months if he has met all conditions and there have been no violations.
Okay, so it's not going to be an automatic termination of the apply.
Yes, Your Honor.
Good. Thank you, sir.
If I may approach.
Please. Thank you. Mr. Allison, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. You can put your hand down. Mr. Allison, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes.
Did you sign it?
Yes, sir.
Do you understand that if I accept your plea that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you? It's not a probation.
No, sir.
You had the $100 cost of prosecution, and that's what got me on that.
Okay.
Okay. So do you understand that you're waiving your right to a trial by jury?
Yes,
There's
sir.
not going to be a trial. There's not going to be a jury trial, right?
Yes, no, sir.
Okay. Mr. Allison, I do accept your plea. Adjudication is withheld. You're sentenced to 3 years probation. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. It was strange the way that Mr. Madden stated the $967 And I thought he said cost and fines.
I thought that was the fine, the court cost for it, Judge.
Okay. Clerk, okay, good. So 967 in court costs and fines. You have no contact with Joseph Coleman. That's directly or indirectly. You can't post anything online directed at Mr. Coleman. You can't apply for early termination at the 18-month mark if you haven't committed any new law violations and have fulfilled all the terms of your supervision. You'll need to pay the $40 per month cost of supervision.
Yes, sir.
Thank you, Mr. Alton. What you, sir?
Thanks. Appreciate it.
That's all I have, Your Honor. If anything,
Yes,
excuse.
sir. Thanks, Mr. Mack. Mr. LaPella. Good morning, sir.
Good morning. I have Daniel Schmidt. He's also present via Zoom.
Yes, sir.
This was set from the last court date we had. The court set it for a hearing on a motion to exclude witness. It was set also in the afternoon docket, so I'm not sure if we were going to address it this morning or this afternoon. Nevertheless, I'm here. I think I think the anticipation, and the state, correct me if I'm wrong, is that they were going to try to locate a witness and make contact with them to verify their existence and availability. We've received several different addresses and they weren't viable. So,
Okay, to the state.
Judge, just to be clear, I haven't had a ton of time to be in contact with the victim, but I was able to speak to him yesterday as I was running out the door. It wasn't a lengthy conversation, but I had emailed the victim and he responded to me. He just caught me at just the right second, and so I was able to talk to him for a few minutes. We're going to coordinate another phone call because he was at work. I was busy with something else. So that way I can get a good address, but I did have contact with him yesterday, finally.
Okay. So, Mr. LaPella, do you want to depose the victim? The alleged victim?
we've tried several times to, and no luck. Every time we sent a process server out, they said it was a bad address and he not lived there at all. So I don't know if the victim is giving the state the runaround on he doesn't really want to cooperate. I don't know. I haven't been able to have a conversation with him. So we're at a loss, Judge. I'm not sure. I kind of thought maybe that he would be present today to verify his intent to participate, but like I said, I'm at a loss.
Okay. I'm pulling your motion that I had for this afternoon. So you're seeking to exclude that person as a witness, correct?
That was our motion, yes, Judge. We had set the case for trial in the interim, but I think the court continued it.
And since the state has gotten in contact with that person, I think that the court needs to order. Do you want to depose that person? I mean, what can I order short of excluding the witness? Make the state produce that person to testify to deposition at a certain time or within a certain period of time?
I think
Judge, if we can just continue this motion until a June docket, so that way I have a chance to have a better conversation with the victim. The 4 minutes that I was able to even get, because somehow the phone call went straight to my phone, so it was a weird few minutes of trying to figure out what's even going on, because I emailed him before the day before, and so it was just a cold call that I got caught with.
I understand. So I'm going to order that if Mr. LaPella wants it, that the alleged victim will submit to a deposition within a certain period of time or no later than a certain date. And then if that fails to happen, Mr. LaPella can file a motion, an amended motion to exclude that person.
when's the next pretrial, Judge?
July 10th.
It's a ways away. I would suggest perhaps my schedule's a little bit awkward this summer. I've got some trips, but probably before July 1, perhaps, something like that. We'd be able to make contact with this guy. If he is viable and available and does want to prosecute the case would like to do something, have him be made available with some type of a
I don't know if my
process.
schedule would accommodate for because the days that I have for private attorneys, I think are already booked. I do have some dates the week of July 4th that I added another private depo date.
Okay, so you want it before the end of that first week of July?
Yes, Judge.
So it would be before July 7th?
Yes, Judge.
Okay. So the alleged victim will be made available to be deposed prior to July 7th. The defendant's motion to exclude testimony is granted in part. That's the relief that's granted if the alleged victim is not made available for their position prior to 5 o'clock on July 7th. Then, Mr. Lapella, you can file an amended motion to exclude testimony.
Will my office be tasked and be subject to the cost of subpoenaing him, or is the state going to be required to present him for a deposition prior to that day?
The state will be required to make the alleged victim present.
Without necessarily a subpoena from my office?
Correct.
Okay, very good.
So just do a notice of deposition, send it to the state when y'all agree on it.
Okay.
It's something filed where I know where it is.
All right, and Your Honor, and then the court gives us leave to revisit this issue if this does not, if the person flies the Ploof again. Okay, thank you. Thank you, Your Honor.
Thank
That's
you.
all we can ask for.
Mr. Schmidt, thanks for being here, sir.
Yes, sir. Thank you very much.
That's all I have, Your Honor.
It's still set on July 10th. Yes, ma'am.
And then we can cancel the afternoon.
Yes, sir.
Thank you, Your Honor.
Thank you. Ms. Merrifield, did you come back in? I don't see her.
Your Honor, she did say that she was going to be, I think, downstairs as well, so kind of bounced around.
Judge Stern. Do I have any pro se's on the docket for this morning?
Is anybody in the audience?
Yeah. I don't see any. Ma'am? Okay, who is that? Lauren, is that? Okay. Yes, thank you. So Jonathan Wanazak, Mr. Wanazak present. 23 CF 130. I'd asked for the hearing from Mr. Wanazak, I believe, to determine whether he qualifies for a public defender. Mr. Wanazak is not present. Is his case set for July? So I'll see Mr. Wanazak on July 10th. Into the public defender.
Your Honor, I have two in the gallery.
Good, please.
If I may call Mr. Edward Pagrin.
this time, in case 21 CF 3204, the state's going to be announcing a dismissal. I just want to put it on the record. We've had no contact with this victim. We've attempted to depose this victim 3 separate times. He has no-showed all 3 times. I have left multiple voicemails, basically reiterating the importance of this victim getting up with me. We have received no contact, and so this is good.
And this is Mr. Pagrin?
Pagrin, yes, sir.
It's 21 CF 3204, correct?
Yes, sir.
Mr. Pagrin, your case is dismissed, okay? Thank you so much, sir.
Good luck, okay? Thank you. Thank you. Your Honor, I have Thomas Ploof. Mr. Ploof is present and approaching. Your Honor, we do have an agreed upon sentence for Mr. Ploof. However, the parties are at odds on a special condition of supervision, the only special condition, which would be whether or not Mr. Ploof has to wear a GPS monitor. So at this time, Ms. Pagrin and I think that the appropriate thing to do would be to enter the plea. We agree on the sentence, other than that one issue. Have this put on the June 12th docket. If we don't come to an agreement on this, I'll file a brief memorandum of law so the court will have whatever case law the defense has. I'm sure Ms. Pagrin will do the same. Worst case scenario, this might be a 5 or 10 minute legal argument on that one point.
So it's whether it's mandatory or
Correct. Correct.
So we would be setting off imposing the sentence until that miscellaneous date.
Okay. But we can go ahead and
Sure. Mr. Ploof, you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. Mr. Ploof, interesting. First off, if you agree with this plea, if you'll sign
He's signed it, Your Honor. That's his signature.
it, it's got defendant in a star next to
That's your
it.
signature?
Yeah, that's my actual signature.
That's your signature?
Yeah, that's my legal signature.
Wow.
It's on my driver's license. That's how I sign everything.
I did a double take too when I first saw that.
Thank you, sir. So, Mr. Ploof, did you read the plea agreement?
Yes, I did.
Do you understand it?
Yes, I do.
Did you discuss it with your attorney?
Yes, I did.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
Yes, I did.
Do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, I do.
Do you believe it's in your best interest to enter the plea?
Yes.
Mr. Ploof, so do you understand that we'll defer the sentencing until July 12th?
June 12th.
June 12th at 9 o'clock. But that at that time, you'll be sentenced to 1 year of community control, followed by 1 year of probation. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision. And if it's legally required, then the court will require you to wear a GPS monitor. Do you understand that?
Yes, I do.
Have any questions for me or your attorney or the state?
Not at this point.
And Your Honor, for the record, count 2 is dismissed in exchange for the plea. We will be submitting a score sheet, but it would reflect 93.6 points. This is a downward departure based on a legitimate uncoerced plea bargain.
If it's okay with the state and Mr. Hines, I'll write on the plea agreement and then ask the state and Mr. Ploof to sign. GPS will be required. GPS will be required.
I think
required twice.
I think probably the appropriate language would be GPS may be required pending legal argument on that particular point. Or if the court wants to just, I think the smart thing to do would be to take the plea today.
And I agree with the plea. I just wanted to put that contingency on the written.
I can tell the court and make the record clear that Mr. Ploof is more than aware of this. He and I have discussed this multiple times just this week.
How about if I write on here, defendant shall have to wear a GPS monitor if legally required?
That's great. I think that's okay. Yeah. Yes.
mind to get
Yes, sir.
that?
On the way.
You know, the state and Mr. Ploof initial that. That'd be great.
Defendant shall wear a GPS monitor if legally required.
Mr. Ploof, I did contract a while before I went on the bench, and so I think about wordsmithing, and I certainly want something in writing that talks about the GPS monitor.
I totally understand.
I initially just.
Good. Yes, sir. Thank you. So, Mr. Ploof, I'll see you on June 12th at 9 o'clock.
Thank you.
Thank you, sir.
Judge, I have Mr. Tim Robbins.
Mr. Robbins.
Mr. Tim Robbins is approaching in 23 CF41.
Yes, sir.
This is on the trial docket. I believe the state may have an announcement.
Judge, we've attempted numerous times to get in touch with this victim. We have been provided an out-of-state address that also makes it difficult to try to serve her with a subpoena and force her presence here. At this point, we have gotten zero response from any attempts to communicate with this victim. So at this time, the state's going to have to announce a dismissal based on the victim's lack of participation.
Mr. Robbins, your case number 23 CF41 is dismissed. Thank you, sir.
Judge, if I may, just real quick, because I got a message from my legal assistant who was watching the court TV.
Does this have to do with Mr. Robbins?
No.
Thank you.
Sorry.
Mr. Robbins is standing there.
Sorry, I apologize.
Thank you, sir.
On Mr. Lanazak,
Yes, sir.
I was contacted, or our office was contacted by Mr. Weinstock. I believe Mr. Weinstock is his attorney. Had some, he had been, I guess he's filing a notice of appearance. I don't know if he has yet or not, but I think he did retain Mr. Weinstock as his attorney. Mr. Weinstock had contacted our office, not completely registered for this case. He is, I think, in Walton today, and so he just requested that he continue to the 710, which is what I think it was. I just wanted to let you know, because I think I heard you make a note that it might have been a no-show, so I just wanted to let you know for the descendants' benefit.
I appreciate it. Thank you, sir. Yes, sir.
Mr. Jeffrey Scott. Mr. Jeffrey Scott Jr. is here in 22 CF2980. The only thing left remaining in this case number is a misdemeanor DUI. The state has agreed for entry of a plea to a lesser included reckless driving. He will be adjudicated guilty, be placed on JCS probation for 6 months, have special conditions of DUI school and a victim impact panel, standard court cost, and I've added a $50 cost of defense since it's a misdemeanor. May I approach with the plea agreement?
Yes, sir. Mr. Scott, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Scott, did you read the plea agreement?
Yes, sir.
Do you understand it? Did you sign it?
Yes, sir.
Mr. Scott, I do accept your plea. You're adjudicated guilty of, it's a misdemeanor, correct?
Yes, it's a reckless driving, second-degree misdemeanor.
And so you're adjudicated guilty of the misdemeanor. You're sentenced to 6 months probation with JCS. You will have to enter and successfully complete the DUI school and the victim impact panel. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's also a $50 cost of defense. Thank you, Mr. Scott.
I believe there's also cost of supervision being on JCS.
Yes, sir. I think that's $50 a month.
Yes, sir.
Mr. Scott. Thank you.
The address of the JCS is on my card.
Okay. Yeah, Mr. Engman is on Zoom. Is that someone's clock?
Yes, sir.
Peter, can you turn on your video and audio?
Yes, sir, I'm here.
Hey, Peter, so the state's proposing a plea as charged, but it would be credit for time served and adjudication of guilt. The only thing you would have to do, essentially, is pay court costs, and you would have to go to a local police station and get your fingerprints taken and submit them to the court.
Okay.
Okay. So what?
No problem.
So assuming that Judge Brown is okay with that, we did this quite a bit during COVID. I think the appropriate thing to do would be to enter the plea and then have you put on for what's called a control date in late June, so you'd have to have those submitted by that date.
Okay.
Would that be appropriate, Your Honor?
Yes, sir.
Okay, so at this time, Your Honor, Mr. Engman is going to enter a plea as charged on count 1. Is there 2 counts?
Just one.
Dismiss count 2 in exchange for the plea to count 1. This would be a no contest plea. Mr. Engman would be sentenced to credit for time served. He would be assessed $615 in court costs, $150 in public defender fees. He would be adjudicated, and as we just discussed, Your Honor, he would have to submit his fingerprints by June 22nd.
Okay. And has Mr. Engman been adjudicated guilty of a felony in the past?
He has previously been adjudicated.
Mr. Engman, if you'll raise your right hand.
Sir?
If you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Engman, did you understand everything that Mr. Klein stated today on the record as far as the plea agreement?
Yes, sir, I do.
Do you understand that you're waiving your right to a trial by jury if I accept the plea?
Yes, sir.
Do you have any questions for me or Mr. Klein's or the state regarding the plea?
No, sir, he's done an awesome job. Thank you.
Good. Mr. Engman, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the $615 in court costs, $150 public defender's fee. You will need to provide fingerprints no later than June 22nd at 9 o'clock. If you fail to do that by that time, then you need to be here in court live on June 22nd at 9 o'clock.
I'll have it done today. Yes, sir.
Okay. Thank you, Mr. Engman.
Hey, Peter, if there's any issues with that at all, just call my office and we'll see what we can do to help.
Yeah, I'm going to add to Mr. Klein because I got to figure out how I got to pay the fines and all that stuff too. So if you don't mind.
Well, so the fines, the judge is asking how long do you want to pay those court costs so that it doesn't affect your driver's license?
It's roughly $800. Can you give me like 3 months and I'll have it paid off at least?
Yes, sir. Why don't we do 6 months, okay?
Okay, that's great.
So if you fail to pay it within 6 months, then it will go to a civil lien or judgment.
Yes, sir. I'll take care of it.
Okay. Thank you, sir.
Yes, sir. Thank you, Mr. Klein. Thank you, Your Honor.
Good luck, okay?
And
Yes,
Your
sir.
Honor, this is a downward departure based on legitimate uncoerced plea bargain. If I may approach with the score sheet.
Yes, ma'am.
Your Honor, I have Mateo McKinnon.
Yes, sir. Thank you. Hello, Mr. McKinnon. How are you doing? Good. How are you? Good.
Your Honor, this is Mr. McKinnon. I believe Mr. Gomez has an announcement.
Yes, Your Honor, at this time, the state has tried reaching out to the victim in this case multiple times. The only contact that we have had is we received a letter, it was much earlier in the case, where she stated that she wanted to drop the no contact order to no violent contact. Since then, she also stated she may be moving out of state. Since then, we do believe that she has moved out of state. We have had no contact with her. Was actually able to get up with her brother, but her brother said that he has had no contact with her. For those reasons, the state is going to be dismissing this case.
Okay. Mr. McKinnon, your case number 22 CF 207 is dismissed. Thank you, sir. Ms. Jacob, are you ready?
Yes, Your Honor. Mr. Stovall is here and present in 22 CF 2612, but we are ready for trial, so I think we probably need to wait.
No, that's fine. You want to talk about Mr. Stovall?
Mr. Stovall, come on. Your Honor, I believe Mr. Rogers will be trying this case for the state.
That is correct, Your Honor. Mr. Rogers had another court commitment this morning, but I'm covering for him, Michelle Sandler, for the state. The state is also ready for trial. Mr. Rogers will be in training at the beginning of next week, Your Honor, but he would be ready on either Thursday of the first trial week or anytime the next trial date. And it would be a pick and go one day, I believe.
Yes, Your Honor, I anticipate possibly 2 witnesses on the behalf of the state, and on our side, only if Mr. Stovall chooses to testify. And I don't expect that to be lengthy testimony. Despite the level of the charge and despite the severe penalties, the facts of this case are relatively simple. And I don't expect there to be a whole lot of dispute about the facts of the case or the testimony that would be presented. So I think it should be a fairly speedy trial. I also don't expect there to be a huge issue for jury selection.
How many on the dime?
Quite frankly, Your Honor, I ask for 30 always just because I like to have a few extras for the ones that don't show up, rather than just a minimum of 22, but I think 30 is more than sufficient.
I would agree with 30, Your Honor.
And you want to try it when?
Your Honor, I'm fine with a pick and go on Thursday of next week. I believe that is the 25th or 26th.
Okay, Thursday of next week. Okay, on the 25th. I do have a second judge then. Whether I've got a second court reporter, that was kind of up in the air. Also, from what the clerk's office says, we don't have it, and I think I sent y'all all the different pieces of the puzzle that I've got. They said that they don't have a second clerk for Thursday. I'll see what I can do to try to work that out.
My understanding, Your Honor, is that I think the state has kind of worked their schedule to make this the only trial for that day. So that's my understanding.
Oh, okay.
But I'm
So
happy
we do
to, yes, Your Honor.
Right.
But I'm happy to wait if you need me to remain.
No, ma'am. I mean, if that's the only case that's going,
Is that it? Okay.
Yeah.
good. Okay.
We've been talking all week trying to coordinate
Yes,
everything.
and that's what I expected, Your Honor. And so I know that I appreciate the state has worked with my schedule as well, so I didn't have to get coverage for other court dates. So I really appreciate that. And so I think that was kind of put on the schedule to make sure that that day was available and to also accommodate the issue with my office being unavailable.
Good. So, Mr. Stovall, that makes it a lot easier. Less moving parts, just me, and the clerk and the court reporters and all those things. But so I'll see you back here Thursday, May 25th at 8:30. The attorneys will get me proposed jury instructions. Before that, I'll do my homework. We'll get up to speed. I'll ask for attorney management to have the honorary members here at 9 o'clock. Between 8:30 and 9, we'll talk about things prepared for you. Okay? So 8:30 on Thursday. I believe the state doesn't have an offer that's out to Mr. Stovall, correct?
Not at this moment, Your Honor. It would be the minimum mandatory at this time.
All offers were withdrawn already.
Okay. So Thursday, May 25th, 8:30. Thank you, sir.
Thank you, Your Honor.
Thank you.
Next is Scott.
Judge, this is Mr. Tinshan Scott before the court in 21 CF 2481. I will acknowledge that the state has filed an amended information adding account 4. We would acknowledge receipt of that information, waive its formal reading, enter a plea of not guilty. In speaking extensively with Mr. Scott at the jail ahead of today, Mr. Scott is going to request a judge trial. We've communicated with the state that is going to be Mr. Scott's request. I believe that
the state is going to be on board with that request, so that would impact our scheduling. Mr. Scott knows that it would be Your Honor who would be trying the case, and that the court would be making factual determinations and legal determinations if he were to have a judge trial opposed to a jury trial. We did sit down and review pros and cons to judge trials versus jury trials, and I believe that that is Mr. Scott's decision and request to the court. I would ask the court to inquire.
Yes, sir. Mr. Scott, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. So, Mr. Scott, it's unusual, very unusual, that a defendant asks for the judge to make the factual determinations. It's not unheard of, but it's certainly not the norm. So do you understand that you have a right to a jury trial where the jury would make the factual determination?
Yes, sir. In the Bible it says he sent down people, certain people to judge. He sent a police to protect. He sent a doctor to heal. He sent a judge to judge. He didn't send no jury to judge me.
Yes, sir.
They can't judge me. I feel better with you judge me. If you give me a life sentence, I'll take that.
Okay. Well, but you're jumping a step when you say, if I sentence you to life. First off, the fact finder, whether it's the jury or me, if it's a judge trial, has to determine that you're guilty or not. Yes, ma'am.
I just want to make clear, I think the point that Mr. Scott's making is that the state would be seeking, if Mr. Scott is found guilty at trial, that the state would be seeking PRR sentencing, since we're talking about one of the charges is a burglary of a dwelling with a battery. Then that charge, if the state has pen packs to provide, Your Honor, and if we are able to meet that burden of the PRR, then Your Honor would have no choice, if he was found guilty, but to send him to a life sentence.
Okay. So a lot in there, Mr. Scott. One is, have you had the opportunity to talk to Mr. McKinney about PRR, which means prison releasee reoffender?
I know everything about this case, sir.
Okay. And you know what the requirements are for the state to prove PRR?
That I got out and I committed a crime within 3 years of me being on.
Okay. And if it's a judge trial and I determine that those facts are accurate, if I find that you're guilty of the underlying crime and that the facts fulfill the PRR, then do you understand it's mandatory? It's not discretionary for me to sentence you to life.
I understand that.
Okay.
I understand.
And to make clear on the record, we're really discussing count 3, which is the PBL, that is the burglary of a dwelling with an assault or battery. Count 1 is a second-degree felony, aggravated battery with a deadly weapon. Count 2 is an aggravated battery with a deadly weapon. And the state has recently added count 4, which is an aggravated animal cruelty, which is a third-degree felony. It is the third-degree felony which, if he were found guilty at trial and the court believed that the state proved PRR, would require a mandatory life sentence.
Okay. Mr. Scott, I understand what you say about the Bible, and I agree with you. And it's interesting that you say that, because what I tell venaries, what I'll tell juries next week, is that my understanding from the research is that jury trials can be traced back about 2,000 years. That's a heck of a coincidence, to Egypt. And so it's really interesting. But I'm looking at only the New Testament, and that was in the Old Testament, correct? So predates 2,000, correct? Okay. It's your call, Mr. Scott. It's up to you.
I want to try by judge.
Okay. And it was interesting, Mr. McKinney said you want it by me. So, I don't get another judge to cover for me, so you aren't surprised with somebody else. I'll make sure that I'm the judge that tries it. So, when are we going to try Mr. Scott's case, and how long will it take?
Judge, we're looking at a one-day trial. I'd like to keep Monday and Tuesday open. My expectation is Tuesday. I have one more witness that we're trying to get service on, which should happen this afternoon. And so it's just that schedule conundrum of whether or not it's for sure Tuesday. That's what I'm planning for, is Tuesday.
Tuesday, May 23rd?
Yes, Judge. But there is a small possibility, obviously, since we won't have a jury, then I don't think it would be a huge issue to move it up to Monday if everything can
Not at all.
line up.
Yes, ma'am. So, Mr. Scott, I'll see you back here no later than Tuesday, May 23rd at 8:30. Okay? Thank you, sir.
I'll let you know whether it's Monday or Tuesday.
I would just do this. I would do it Tuesday at 8:30.
So we're setting Tuesday at 8:30?
Right.
Judge, I do have one more in the gallery.
Yes, sir, please.
Andrew West.
Mr. West.
Good morning, Your Honor.
Good morning, sir.
Andrew West is here in 23 CF 599. He's on the trial docket. I believe the state may have an announcement.
Judge, we've tried numerous times to get in contact with the victims in this case. We have never had any contact from the victim in the case. At this point, we would have no choice but to dismiss the case due to lack of victim participation.
Okay. Mr. West, your case number 23 CF 599 is dismissed.
Yes, sir.
Thank you, sir. Oh, it's very good. Yes, ma'am. Thank you.
Good morning, Your Honor.
Good morning, ma'am.
My apologies, I was with Judge Scott. Brady Merrifield on behalf of Toriano Marsh in 22 CF 2119. Judge, if we may approach for a moment.
Yes, ma'am.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Engman Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and or criminal defense lawyers.
Thank you, Your Honor. That's all I have this morning.
Thank you. Okay, who's next?
Next will be Jasmine Williams.
Thank you.
Judge, this is Ms. Jasmine Williams before the court in 3 case numbers, 22 CF 673, 22 CF 2287, and 22 CF 2523. And then I added this on early to this docket because I did receive a report back from the evaluator related to Ms. Williams' competence to proceed. Has the court had an opportunity to review that report?
I have, yes, sir. By Dr. Zeman?
Yes, Judge. And in that report, there is a recommendation that Ms. Williams would likely be able to regain competence within a short period of time, but is recommending Florida State Hospital.
to regain confidence.
To the state?
Judge, we had an opportunity to review that report, and we stipulate to the findings in the report.
Okay.
Why?
I believe there is a misdemeanor case that we might need to address.
Okay.
It's 23 MM 102 and 23 MM 71.
Is there anyone else that could do an evaluation on me? I felt like I was trying to be kind and cordial when I was talking to him or whatever, and I don't know, he was like, do you want to go to Phoenix House? And I got angry and like, y'all just got me locked up. I don't want to go to Phoenix House. I want to be let out. This, that, and the third, and I'm not, it's kind of like being like, why do you think the kidnapping will let you back out? Why? There's no reason for me to still be locked up. And I'm begging you, I'm so stressed. It's like I'm having a nervous breakdown. Like I don't need a competent, whatever the word is, evaluation. I just want to go home. I want to get out of here. And y'all got me just locked up, like I'm just like a loose person on the loose.
And Ms. Williams, when I went through the evaluation, it was somewhat unique in how it oscillated back and forth between unacceptable, questionable. There were different things that were in there. And so Mr. McKinney's pointing out about the 6-month rehabilitation time period. I look forward to that. I look forward to seeing you again after you go to the Florida State Hospital. Hopefully it'll be within 6 months.
Is this, I just don't understand. I just have to say this because at this point my head is like literally hurting so bad. So I'm Jasmine.
Yes, ma'am.
So,
Jasmine Williams, and you're 28, correct?
Yeah.
Okay.
So
Ms. Williams, they'll explain more things to you at the Florida State Hospital. And once they say that you're okay, then you'll come back before me.
How are y'all gonna just...
I've got to rely on the experts, Ms. Williams.
These people are running around with the whole... That sounds so crazy, right? So you're you.
Ms. Williams, I do find you incompetent to proceed.
You find me incompetent to do like
to proceed with this case.
There's a whole other Jasmine running around. That's crazy.
I don't find another Jasmine running
A
around.
whole other BMW.
Thank you, Ms. Williams. We'll see you after the Florida State Hospital.
But that's crazy.
Judge, I'll provide an order for the court.
Thank you, sir.
Oh, Lord.
Next is Mrs. Klein.
Who we got?
Dana.
Yeah.
Next, Dana Nelson.
Thank you. Mr. McKinney, you're going to provide an order on that?
I will, Judge.
Thank you.
Your Honor, this is Dana Nelson.
Yes, sir.
I met with Ms. Nelson yesterday at the jail, provided her quite a bit of documentation to explain the situation she's currently in. I've just talked with Ms. Nelson. I believe that she would accept the state's offer to plead us to a no valid driver's license. With an adjudication of guilt, this is a second-degree misdemeanor. I was just telling Ms. Nelson that if she has any concerns that any other charges could arise out of this April 15, 2022 incident, that I'm sure the state would probably announce they would not seek any new charges for any offenses on that date. I don't know what other assurances I can give Ms. Nelson, but I think this would also involve merging and dismissing any ticket associated with this offense. I don't know what else to tell them.
Okay.
And that's correct, Your Honor. The state can make those representations. We will not be charging Ms. Nelson for any more charges that arise out of this particular incident today. As of now, there are no other charges that are pending in benchmark other than this one. Furthermore, the state would be willing to merge and dismiss all the traffic citations that arose out of this incident as well. So
All the traffic citations relating to this one date?
Yes, Your Honor.
What is that date?
April 15th, 2022.
What about these, Mr. Clemens? All these things?
Let me grab my computer real quick. Let me grab my computer.
Ms. Nelson, how are you?
I'm nervous as a catfish.
As a catfish, okay.
I was going to say something else, but I don't say.
And I appreciate that.
Ms. Nelson just has a question, Your Honor, about, I had printed up something off of Benchmark, and it's a little confusing to Ms. Nelson, so I just wanted to show her that that she doesn't have any reason to be concerned. She's concerned about, on the right-hand side of this print, or left-hand, I keep saying it, the left-hand side of this printout, there's a list of case numbers. All that does is it's showing my recent activity in Benchmark. And so I'm just trying to pull up Ms. Nelson's case to kind of show her. See how it says search, search, court docket, my open cases, and it goes down. Now yesterday when I was printing off this for 2 days ago, I had done a ton of work in Benchmark that day. That's why there's all those case numbers. This morning, I've only searched your name one time. That's why it just says name 100333.
So, okay, here's what I got to say, Your Honor, if you don't mind. Mr. Statesman, I'm going to go ahead and bow down to this, knowing it ain't real, but I'd like to get out of jail, so if there's anything else, could you just kiss me now?
I don't know how to respond to that. There is nothing else. I'm looking at your benchmark. There is nothing else other than this case that's open. The state is not going to be seeking to create charges or charge you with anything new out of any incident that I'm looking at here in benchmark. You will have no open cases after you sign that in Okaloosa County, and we are agreeing to merge and dismiss any of the traffic citations that are attached to that particular case as well.
And then,
so the record's clear, Your Honor. What Mr. Gomez is talking about is 22 TR 1595, 22 TR 1594, and there was the citation issued for driving as a habitual traffic offender issued as part of this particular case. So those two traffic cases would be merged and dismissed.
Thank you. Ms. Nelson, if you'll raise your right hand.
sir, that's against my religion, but I promise to tell the truth. I don't raise my right hand to a note that's against God.
Okay, how about an attestation?
What does that mean? That's
It
too
means
big
that
for me.
That you are asserting that you will tell the truth.
Yes, sir, I promise.
Okay. And you won't raise your hand to that?
No, sir, that's against God.
Okay. Ms. Melson, did you understand everything that was said today on the record?
Yes, sir.
Okay. So here's what I understand, is that you'd be adjudicated guilty of the misdemeanor. You'd have to pay the court cost, $150 public defender's fee. I'd ask you how long you need to pay that, and I'd give you some number of months for that. If you fail to pay those amounts within that time period, then it will go to a civil lien or judgment. No criminal thing, the criminal case is gone. All of your traffic tickets and traffic citations would merge into this case, so you wouldn't have any cases surviving arising from any incident on April 15th of 2022, and your case would be disposed of. Is that what you wish to do?
I do.
Okay. Do you have any questions for me or Mr. Clines or the city?
No, sir.
Okay. Ms. Melson, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll just need to pay the court costs, the public defender's fee. Madam Clerk, what would be the approximate amount? So $450. Ms. Nelson, how long will it take you to pay $450?
Well, I got to go to U.S. Marshals, they say. It might take me a little bit coming out, because,
I would ask the court for 12 months for this case.
Ms. Nelson, if you fail to pay those amounts within a year from today, then they'll go to a civil lien or judgment, okay?
And that means against my license,
Yes,
that I'm
ma'am.
not ever getting back? Okay. Your Honor, I do want to tell the state this. In 2018, I did get my license. I was on contract for Milton, Panama City, Okaloosa, and Bonifay, Florida. I paid them off. I got on contract. I paid $550 to get my license at Niceville. So I did have license in 2018. I was not sentenced as a habitual offender of traffic.
Thank you, Ms. Nelson. We'd like you, ma'am.
So does this mean I'm getting out of this jail?
You're not being held in our jail because of this case.
So I'm through with this case. I'm
Yes,
going to just
ma'am.
wait for something else.
Yes, yep, and Dana, I will keep tabs on this. If you're not out of jail by Monday, I'll call the marshals myself.
You promise?
I promise.
Thank y'all.
Next is Adrian Riva Garcia.
Good morning, sir. Good up.
How are you? Did you have a chance to read this? So if you have no questions, this was Judge, we have reached an agreement for Mr. Adrian Riva Garcia in cases 22 CF 2966 and 19 CF 2475, which is a felony violation of probation. The agreement that's been reached is for Mr. Riva Garcia to enter a plea as charged in 22 CF 2966. He'll be placed on 3 years of probation with special condition of a mental health evaluation and any recommended treatment. Restitution in the amount of $6,000, $733.48 to the Florida Sheriff's Risk Management Fund. Standard court cost. In 19 CF 2475, his probation would be revoked and terminated. There's a $100 BOP fee, a total of $250 cost of defense. Given the amount of restitution, I would ask the court to consider waiving the cost of supervision. May I approach?
Yes, sir. Any adjudication?
He will be adjudicated guilty. He has not been previously adjudicated guilty before, and he does understand that this case will adjudicate him and make him a convicted felon.
Mr. Garcia, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. Garcia, it's been a while since I've said this, so let me make sure I get the language correct.
Sure.
Well, Mr. Garcia, let me start with the end of this. If I accept your plea and you're adjudicated guilty, if you're not a U.S. citizen, do you understand that it shall subject you to deportation? And before I ask you to respond to that, I used to say for years, this may subject you to deportation. The appellate courts, from my understanding, say I have to say it shall subject you to deportation. I'm not a federal judge. I don't do deportations. I'm a state court. So do you understand that if I accept your plea and you're not a U.S. citizen, that it shall subject you to deportation?
Sure, I understand everything.
Mr. Rico Garcia, did you read the plea agreement?
Yes, I did.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, I did.
Did he answer all of your questions?
Yes, he did.
Are you satisfied with his representation?
I'm thankful and I'm happy I'm going home today. So all I can say is God is good, and I'm sorry for all this struggle. And I'm going to take a minute just to appreciate you, for all. I wish I didn't have to go through this, but I couldn't help it. I'm sorry.
Mr. Garcia, did you sign the plea agreement?
Yes, I did.
Mr. Garcia, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation. You'll need to you'll need to submit to a mental health evaluation within 30 days from today. If any treatment is recommended, you need to begin that within 60 days from today. You need to pay restitution in the amount of $6,733.48 to the Florida Sheriff's Risk Management Fund. That's in the new case. In the VOP case, your supervision is revoked and terminated. You need to pay the court costs, a total of $250 public defender's fee, $100 cost of prosecution. Mr. Garcia, how long do you want? Well, the court does waive the cost of supervision because of the amount of the restitution. You'll have that 2 years. I'm sorry, you'll have the 3 years to pay the financial amounts. Mr. Rico Garcia, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, I do, Your Honor.
Okay, if you wait 1 second. Probation, do you have a question?
Well, just make sure on the 19th day, Your Honor, it was revoked and termed and no new supervision?
Correct. Thank you. Thank you, sir. Good luck to you.
Yeah, thank you so much.
Yes, sir. You're welcome.
Next is Joshua Rogers.
If I want to? Correct. Thank you so much.
Yes, sir.
Mr. Garcia?
Rogers.
Judge, this is Mr. Joshua Rogers before the court in 22 CF 1852. May I approach with the state?
Yes, sir.
Rogers, we've been in extensive negotiation with the state. We have made a counteroffer to the state that we are proposing to resolve the matter. It doesn't sound like we're able to enter that in court here today, but that is something that we're still moving forward towards. As a backstop, I do want to leave the case on the trial docket.
Mr. Wright? Mr. Rogers? Yes, sir. Mr. McKinney just used the term that I used up here. And I always want an end to something. The rules of judicial administration say the court will take control of the docket and move the cases forward. So the attorneys really believe that this is going to resolve without a jury trial.
Okay.
But I said I want a backstop to it. So we're planning on going to trial. If it doesn't end in a plea, then we're going to go to trial on Monday, June 5th.
That's 2 weeks.
Right. It's 2 weeks from Monday.
Okay.
Okay. So I'll see you here no later than that. And I'll probably see you in any event that time.
Okay.
If a plea's entered, then I'll talk to you that morning about that. If not, then we'll pick a jury.
Okay.
Okay. Thank you, sir.
Next is Peyton Thomas.
Judges, is Mr. Peyton Thomas before the court?
Yes, sir.
Mr. Thomas is here in 2 case numbers, 22 CF 410 and 22 CF 471. Both were on the trial docket. However, the state did extend an offer in the 22 CF 471 case. In that case, Mr. Thomas is facing a 3-count information. I do not have a written plea agreement because I was unsure of the exact terms, but the plea would be to misdemeanors only in 22 CF 471. It would be reduction to a fraud by obtaining food or lodging, a misdemeanor, first-degree misdemeanor, as charged in count 2, and plea to a petty theft in count 3. The agreement would be time served to the misdemeanors in that case number. I've spoken with Mr. Thomas about that. He wishes to accept the state's offer in 22 CF 471. The intention, if we do not have a resolution on the other case, would be to set that case for trial. I'll defer to the court, which one the court wants to address first.
Okay. First off, I know that Madam Clerk's going to ask for the statute number for that lesser included. Do you have that available?
Yes, sir.
Mr. Thomas, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Thank you, sir. You can put your hand down. Mr. McKinney, do you have that number?
The lesser for the petty theft is 812-014 sub 3 sub A, and I will have to look out the fraud by obtaining food or lodging misdemeanor. I'm assuming that it's in the same section, but I want to make sure.
Okay, good.
I'll provide that to Madam Clerk.
Thank you. So, Mr. Thomas, a couple things are going on. One is that if I accept the plea, it only disposes of the case that you were charged with defrauding an innkeeper, trespassing principal, the larceny. It only disposes of that case. It does not affect at all the case where you're charged with burglary of an unoccupied dwelling and petty theft. Do you understand that?
Yes, I do.
Okay. Do you wish to enter the plea that Mr. McKinney just stated today on the record to the misdemeanors in 22 CF 471?
Yes, I do.
Okay. Do you understand that you're waiving a trial by jury in that case?
Yes, I do.
Do you have any questions for me or Mr. McKinney or the state about that plea?
No, I do not.
Mr. Thomas, I do accept that plea. You're adjudicated guilty. You're sentenced to, and it's 2 misdemeanors only.
Correct.
You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. Mr. McKinney, how long does Mr. Thomas want for that to pay those amounts, or how do you want to do it?
Judge, we would ask for 6 months.
Okay. So if you fail to pay those amounts, Mr. Thomas, within 6 months of your release from jail, then they'll go to a civil lien or judgment. Okay, so now on 22 CF 410,
There's a one-count information for burglary of an unoccupied dwelling, a second-degree felony, and we remain ready for trial.
Okay, to the state?
We do as well, Judge.
Okay, when's it going to be tried?
Judge, I was hoping to be able to set this one for that Monday, June 5th.
Okay.
That's what we just talked about from Mr. Rogers.
Okay, so how, is it going to be 40 on the Venari?
Yes, Judge.
Okay. So then I'll just order one Venari for 40. Okay, so Mr. Thomas. It'll be a one-day trial or more?
It should be a one day.
I agree.
So, Mr. Thomas, that means that I'll see you back here on June 5th at 8:30. The attorneys will give me their jury instructions and homework before that date. The jury pool will be brought in that morning, and we'll try it that day. Okay. Good. Thank you, sir.
Yes, sir.
Right over here, Mr. Thomas. Next is Jonathan Wallace.
Judges, Mr. Jonathan Wallace, for the court in 22 CF 3011. Judge, Mr. Wallace is here in 22 CF 3011. I did meet with him extensively at the jail yesterday. He is charged with one count of aggravated assault by threat with a deadly weapon, which is a third-degree felony. I do not have a written plea agreement, but he's just told me in court today that he does wish to accept the state's offer of 6 months in the Okaloosa County Jail for a plea as charged, with credit for time served, if that offer is still available.
The offer had been withdrawn on Monday. But at this point, I think we'll go ahead and let him plead today.
Okay. So it would be an adjudication of guilt?
Yes, Judge. And just to be clear, the reason that I'm renewing the offer is merely because Mr. McKinney was not here on Monday. So just to be fair to Mr. McKinney's representation of his client.
Okay. So it'd be 6 months Okaloosa County Jail with credit for time served, court cost $150 public defender's fee, right?
Yes, Judge.
Okay. Mr. Wallace, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Wallace, so did you understand what I just stated?
Yes, sir.
Do you understand that you're waiving your right to a trial by jury?
Yes, sir.
Have any questions for me or Mr. McKinney or the state?
No, sir.
Mr. Wallace, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served. You'll need to pay the court costs, $150 public defender's fee. Madam Clerk, is that $900 $867 is the court cost plus the $150. So, Mr. Wallace, how long will it take you to pay approximately $1,000? How long do you want to pay that?
As of right now, I mean, as long as I get, 'cause I still got payments from the previous stuff.
So, Mr. Wallace, if you fail to pay that within 1 year from today, then it will go to a civil lien or judgment, not criminal, but civil, okay?
Okay.
Thank you, sir. Good luck to you.
All right. Thank you very much.
Next is General Wright.
Thank you. Mr. Wright.
Judge, this is Mr. Wendell Wright. Mr. Wright is here before the court in 21 CF 1776, 21 CF 1772, 20 CF 2804, and 20 CF 3187. I have been in discussions with the state. I have been in communication and saw Mr. Wright at the Okaloosa County Jail. This case is set for the jury trial docket in 21 CF 1776.
Okay. When do you want to try it?
Your Honor, my law enforcement officers are training next week, so they're available the following week. Given that the state has already announced they would take Monday, the state is available any other time that week at the court's discretion. I believe Tuesday and Wednesday would work. Given the amount of counts in this case, the state would not want to commit to a one-day trial just in case. The state also has 2 notices to personally serve upon Mr. Wright today. He has several cases with the court. They were served in other cases, but not this one. We want to make sure that we follow the proper procedure.
Yes, ma'am.
So we have already e-served a notice of intent to seek prison release reoffender enhancement and a notice of intent to seek habitual felony offender enhancement. So for the record, we would serve them on Mr. Wright at this time. And for the record, that would increase his exposure. In this case, he has one qualifying offense, which would be aggravated assault on a law enforcement officer. He would be facing a 15-year minimum mandatory in that case. If the state were to choose to seek habitual felony offender, I believe that would double his exposure, excepting on misdemeanors and his controlled substance.
And there's no offer from the state to Mr. Wright at this point?
Mr. Wright had received a very favorable offer from the state. It was withdrawn, and it remains withdrawn.
Okay. So how many on the denier?
I believe 40 would be sufficient.
And so you want to set it for Tuesday and Wednesday, or Wednesday and Thursday? Friday? Whatever you want.
Judge, may we call Mr. Wright back at the end of the docket? He wants to have a discussion with me, and I'd like to have a discussion with the state.
Okay, before we do that, let me just make sure that I understand what happens if nothing's resolved, okay? So let me just go through, if you don't mind. Let me finish making sure that I can set the stage for a trial if that's where it's going to go.
Yes, sir.
So 40 on the Venari, and what days would it go?
Tuesday and Wednesday would be perfect, Your Honor.
Okay. So it would be the June 6th and 7th. Okay. Mr. Wright, I'll see you later this morning, okay? Thank you. Yes, ma'am. Yep. Okay, we'll take a 10-minute recess and then we'll come back and finish up the morning.
All rise.
Your Honor, before you speak up, I just wanted to read this beforehand. So I'll be dealing with that beforehand.
Okay, thank you.
Hi, I'm Wanda Roberts.
until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Thomas Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Papa's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
But we've taken care of it. It's Ernest Machino.
Yes, sir.
We've taken care of it, so I would withdraw the motion at this time to free up the docket this afternoon.
And just for the court's record, we have requested the certified convictions that were requested in the motion. We understand where Mr. Swiatek is coming from, and we want to make sure that we have the score sheet correct as well with the NCICs and out-of-state charges. It does get a little bit confusing, and so we've requested those certified convictions from California. Once we get them, we'll provide them to Mr. Swiatek, and based on the information contained in those, we'll address the score sheet appropriately at that time.
Okay, so the motion is withdrawn in 22 CF 1486. Do we have that set for the next pretrial?
Yes, it is.
Okay.
And when is the next pretrial?
July 10th. Yes, sir.
That should be fine.
Sounds good. Thank you, sir.
Okay, thank you, Judge. Thank you, Mr. Phillips.
Mr. Catalina?
Thank you,
Your Honor, I only have one case on the docket. It's Ms. Yolanda Perez, case number 23CF61. Ms. Perez is present. You approach it.
Oh, Ms. Perez.
Your Honor, we will be withdrawing our previously entered plea of not guilty and enter a plea as charged of no contest with the understanding that she would be adjudicated guilty. 3 years probation, 48 hours in community service, $615 in court costs, and we're asking for the community service, if it's possible, to be able to pay at the statutory rate.
No objection.
May I approach?
Yes, sir. Thank you, sir. Thank you. Yes, sir, absolutely. Thanks for letting my office know.
Yes, sir.
Ms. Perez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Ms. Perez, did you read the plea agreement?
Yes, sir.
Do you understand?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes.
Ms. Perez, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation. You'll need to perform 48 hours of community service work. You can pay that off if you wish to. You'll need to pay the $615 in court costs during that probation. Did you all say something about waiving the cost of supervision, or nope?
We're going to ask for a waiver of the supervision costs, Your Honor, because of her job. She's having financial difficulty at this time right now.
Ms. Perez, how much money do you make per month?
Well, now I'm looking like maybe 800, maybe.
$800 a month?
Oh, a month?
Yes, ma'am.
I said like maybe 1,500.
Okay, when you were saying 800, is that 800? How long a period were you thinking?
A week.
Okay.
But I'm gonna have a knee replacement done too, and but I'll still have my income. I'm saying like.
On your knee, have you got a surgery scheduled for that?
I have to go take a test for no smoking. And then,
interesting, isn't it?
Yeah.
Okay. Ms. Perez, I'm not going to waive the cost of supervision at this time, but if you go into surgery or anything, talk to probation.
Yes.
And then you can file a motion with the court to waive the cost of supervision for that time that you're not able to work, or you have restricted work conditions, okay?
Okay.
Thank you. Thanks, Ms. Perez.
Thank you, Your Honor. That's all I have.
Thanks, Mr. Cavalier. Okay, who's next? Did you want to do Zachary Florence?
Sure. Zachary Florence, can you keep it?
These are case numbers 21 CF 2038 and 21 CF 2088. Well, Mr. Florence. Mr. Florence, thank you for letting me look at the plea agreement first. I'll give it back to you in just a moment.
I actually have an assigned original. That was your copy. I've already given Madam Clerk a copy, or let her get everything written down, same with probation.
Okay, so Mr. Florence, I just want to make sure that I understand the total of this before we start talking about it individually. So the way that I read it is that it's a total of 40 years with the Department of Corrections, and it's followed by 10 years of probation.
It's actually going to be 35 years. in the Department of Corrections, Your Honor, followed by 15 years of probation.
Okay.
That's the intent of the
And there
parties.
was an ambiguity on the count 16 through 30, because that could have added up to a lot more than that.
And that's why I want to make sure that everybody's on the same page. And so the intent of the parties here is that Mr. Florence is going to be sentenced to 35 years in the Department of Corrections, followed by 15 years of sex offender probation, total. But we've had to chop it up to make it legal, essentially. So I will walk through this as slowly as I need to make sure we get this all squared away. In 21 CF 2038, that as currently charged as a capital sexual battery, Mr. Florence is going to be entering a no contest plea to the lesser included offense of attempted sexual battery on a victim less than 12 years of age. I talked with Ms. Barrickman, I conferred with Mr. McKinney. The attempt on that will drop the capital felony to a first degree felony. Mr. Florence would be sentenced to 30 years, 360 months in the Department of Corrections. That will be with credit for all time served. As part of that particular case, the 2038, he will be designated as a sexual predator. He will be assessed $616 in court costs, a $50 application fee, and a $100 public defender fee. 21 CF 2088. Mr. Florence is going to be entering a plea as charged on all 30 counts in that case. Count 1 will be 5 years in the Department of Corrections consecutive to the 30 years in 21 CF 2038. And I explained to Mr. Florence and why it's not on the plea form is because that's a consecutive sentence. He doesn't have any credit on that. All the credit that he's built up so far is toward the 30 years. So that's why there's no credit for time served on that particular count. Count 2, Mr. Florence will be placed on 5 years of sex offender probation consecutive to the prison sentences imposed in 21 CF 2038 and count 1 in the 2088 case.
So why doesn't that total 40 years versus 35?
Because that's sex offender probation.
That's probation. Got it.
Yes.
Okay, good. Thank you.
Count 3 is 5 years sex offender probation consecutive to counts 1 and 2. Essentially, it's consecutive to count 2. So that's now we're at 10 years of sex offender probation, and count 4 would be another 5 years of sex offender probation consecutive to the other 2 probation counts.
Okay.
Counts 5 through 15, Mr. Florence will be sentenced to 60 months in the Department of Corrections with credit for all time served, and that's because that is concurrent to the 21 CF 2038, the 30 years. And then counts 16 through 30, those are all second degree felonies.
Okay, wait, hold on. One second. So we've got 30 years in 2038, and then 5 years in 2088, count 1.
Correct.
And then you got it concurrent. Yes, sir. Okay, I'm with you.
Okay. And then counts 16 through 30, those are second degree felonies. Mr. Florence will be placed on 5 years of sex offender probation per count, concurrent on all of those counts, and also concurrent to count 4, which is the last 5-year period of probation.
So concurrent to each other and to count 4.
Yes, yes.
And counts 5 through 15 are concurrent within themselves.
Correct. Yes, Your Honor. Thank you for clarifying that. Those are concurrent to each other and to the 2038 case.
And all of the probation is sex offender probation.
Correct. And there are special conditions at the bottom of this. Those special conditions are that Mr. Florence, while on supervision, will wear a GPS monitor as a condition of probation. He will have no contact with the victim or the victim's family. And I have discussed with Mr. Florence the fact that by the time he is released from custody, if anybody in his family is requesting contact at that point, we're talking 28 years from now, then they can go ahead and address it then with a whole new set of judge and state attorney and defense attorney. But as of right now, it's no contact with the victim or the victim's family. He will forfeit all seized devices. He will have no contact with minors. He will not have any internet or internet-capable devices while on probation. The court will reserve jurisdiction for 1 year to determine an appropriate level of restitution. He will be assessed $616 in court costs and a $100 public defender fee. And on the official, I had to white out, I put the court costs like twice. I don't know why I did that. But that's the complete terms. He would be adjudicated, and I do have a score sheet, and there is no objection to the score sheet. If I may approach?
Yes, sir. Mr. Florence, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. So, Mr. Florence, that's a lot. That's why I wanted to understand the macro picture is 35 years with the Department of Corrections, credit for time served on the first 30 years, no credit for time served on the 5 years that follows that, and a total of 15 years sex offender probation. So is that the plea that you wish to enter?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
High school diploma.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what was stated today on the record?
No, sir.
Mr. Florence, to make sure that no one's coerced you into entering this, has Mr. Kleins or anyone else told you, Mr. Florence, if you do not enter the plea today, you shall be sentenced to 50 years in prison or any other definite sentence?
Okay.
Mr. Florence, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. In 21 CF 2038, you're adjudicated guilty to the lesser included offense of attempted sexual battery on a victim less than 12 years of age. You're sentenced to 30 years, 360 months with the Department of Corrections with credit for all time served. You're designated as a sexual predator. You need to pay the $616 in court costs, $50 application fee, and $100 public defender's fee. In 21 CF 2088, you're adjudicated guilty on each charge. In every count, count 1, you're sentenced to 5 years Department of Corrections, consecutive to 21 CF 2038. Count 2, sentenced to 5 years sex offender probation, consecutive to the prison sentences imposed in 21 CF 2038, and count 1 in 21 CF 2088. Count 3, you're sentenced to 5 years sex offender probation, consecutive to counts 1 and 2, and also that's consecutive to 21 CF 2038. Count 4, you're sentenced to 5 years sex offender probation, that's consecutive to counts 1, 2, and 3, and 21 CF 2038. Counts 5 through 15, you're sentenced to 60 months with the Department of Corrections with credit for all time served, and that's to run concurrently, run at the same time, to the sentence imposed in 21 CF 2038. And counts 16 through 30, you're sentenced to 5 years sex offender probation, and that's per count, and that's to run concurrent to count 4 and concurrent between themselves, run at the same time. You'll need to wear a GPS monitor during your supervision, have no contact with the victim or with the victim's family. All the seized devices are forfeited. You'll have no contact with any minors, no internet or internet-capable devices while you're on probation. The court does award restitution, but reserves jurisdiction for 1 year to determine the amount of the restitution if the state files a petition or a motion. You'll need to pay the $616 in court costs in this case and a $100 public defender's fee. Mr. Florence, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Florence.
And Your Honor, if I may, the victim is PF. Her date of birth is 8/4/2017, and her guardian is Ms. Haley Jacobs. She was contacted in accordance with Marcy's law, and she's in agreement with the plea.
Thank you, ma'am.
And we will submit a predator order and a device order to Your Honor.
Okay, thank you. And just for the record, once again, the intention is a total of 35 years with the Department of Corrections, followed by 15 years of sex offender probation.
That's correct, Your Honor.
Yes, Judge.
Thank you.
All right, good luck.
Next is Casey Maston.
Your Honor, may we approach briefly on this one?
Yes, sir.
Yeah.
I don't know. No. Mr. Weisbach, no.
Hi, Judge.
We're talking about a case.
Mr. Weinstein, if you'll stay. Yes, sir. Mr. Weinstein.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Engman Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
So it doesn't sound like there's any downside to, your attorney has moved to modify the bonds from cash or professional bonds, those same amounts to be signature bonds. So you'll be able to sign yourself out, or at least you'll be able to sign for those bonds today. They'll all be signature bonds. The same prior pretrial conditions are imposed that were previously imposed. So all of those same conditions are there. If you fail to show up when you're supposed to, then you'll owe those dollar amounts. Mr. Kleins has informed me that you have stated that if you're released from custody in Georgia, that you'll immediately contact him.
Yes, sir.
Are we going to continue it or set it for July 10th? Or do you
I was going to
want
ask the court for a
September 11th?
one-cycle continuance to the September docket.
Let's do that.
Objection.
So, Mr. Maston, I'm continuing your hearing until September 11th at 9 o'clock to the extent that you can, stay in touch with Mr. Klein. Okay?
Yes.
And I have provided Mr. Maston the notice of next court date and wrote down 9/11 and 9 o'clock. I've also discussed with him today the fact that if he's up in Georgia and it's essentially a status conference or something, he can appear by Zoom.
Yes, sir.
Yeah, that's what I was going to
Good. Thank you, sir.
Mr. Weinstock.
Mr. Weinstock. Ready? And thank you for the note. I received that.
There was an accident on I-10 and 285. So if you want to get off 285 to go south to come down here, you can't. So I had to go back up north to 90 to 85 down. And let me tell you, 85 is a parking lot, both north and south.
Wow.
Don't go on 85 if you can help it.
Okay.
All right. Meanwhile, I am here. I just got got retained to represent Jonathan Lonsick, 22 CF 130, and I'm requesting continuance.
Okay, and that was for a status conference. I think the reason why it was a status conference was for, there were some financial questions about whether he qualified or not, was all I could figure when I was doing my homework. So I think we have Mr. Lonsack for July 10th at 9 o'clock. Is that what you're seeking, just the next pre-trial?
That'd be fine, Your Honor.
Okay, yes, sir. I'll see you then.
Thank you, sir.
Thank
That's
you,
all I
sir.
have. Thank you.
Good seeing you. Sorry about the parking lot. Not a bit. I've just got to find you.
Correct. Yeah, that's pretty good.
Your Honor, this is Rosa Steele.
Okay.
From the 130 arraignment docket.
Thank you.
Judge, this is Ms. Marissa Steele before the court in 23 CF 887. Ms. Steele has a 2-count information. Count 1 is a 3rd-degree felony. Count 2 is a 1st-degree misdemeanor. The state has sent a written offer in discovery that I received and discussed with Ms. Steele very briefly today. The agreement, if Ms. Steele were to enter it, would be a plea as charged. She would be adjudicated guilty, be sentenced to 12 months of drug offender probation, followed by 24 months of regular probation. Standard court cost of $615, a $150 cost of defense. She must complete a substance abuse evaluation within 30 days and begin any recommended treatment within 60 days. There would be random urinalysis. She would have to complete 24 hours of community service work. Based on the possession of controlled substance, there would be a driver's license revocation for 1 year. And then she must maintain gainful employment, and if she is not gainfully employed, she must complete 5 job applications per week. In hearing that offer from the state, Ms. Steele, is that something that you wish to accept?
Yeah,
Are you sure?
not really, but I don't want to sit in the county jail either.
Okay. Ms. Steele, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? You have to
I
say
do,
it.
sorry.
Yes, ma'am. You can put your hand down, Ms. Steele. So, Ms. Steele, court doesn't make you do anything as far as accepting a plea. I can't make the state offer you something. I can't make you accept it. You've got to decide what you think's in your best interest, listening to the advice of your attorney, but then you decide what's best for you. If you want to enter the plea, we'll talk a little bit about it. If you don't, then I will set this for a pretrial conference on July 10th, and we'll be heading toward a trial ultimately if it's not resolved before that. So what do you wish to do?
I mean, judging off the fact that my daughter's about to go through surgeries and stuff, I can't really sit in the county jail until July, so I'm willing to take the probation.
Okay. Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
I do.
Do you have any questions for me or Mr. McKinney or the state regarding the plea agreement?
I do not.
Have you ever been adjudicated guilty of a felony before?
I believe so.
Ms. Steele, I do accept your plea. You're adjudicated guilty. You're sentenced to 12 months drug offender probation, followed by 24 months regular probation. You'll need to pay the $40 per month cost of supervision, $150 public defender's fee, and the court costs. You need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. Your driver's license is suspended for 1 year. You'll need to obtain a job or perform 5 job applications per week until you've obtained a job. Probation, what if I'm confused?
And Judge, I'm going to ask probation. There's usually a standard curfew time period for the drug offender probation. I wanted to make sure that those times were announced on the record.
Your Honor, usually it's 7 to 7.
Okay. Ms. Steele, the drug offender probation, Mr. McKinney's correct. Did he talk to you about a curfew that's going to be in effect?
They can modify that based on. And Judge, we would just ask that that time period be allowed to be modified for a worker school.
Yes. So, Ms. Steele, I don't do a bait and switch on you. So if you feel that way and you say, I don't want to enter the plea, we'll stop. Okay?
That's okay.
But the offer from the state is there be a 7 p.m. to 7 a.m. curfew during the first 12 months of your probation. Certainly the probation has the latitude that they can modify that for any jobs you have. Do you still wish to enter the plea?
Yes.
Ms. Steele, I do accept that plea, so that's the sentence. Thank you, ma'am.
Thank you.
Can we ask for time served on the misdemeanor?
Time served on the misdemeanor. Ms. Steele, when you're released from the jail, then you need to immediately report to probation. If it's before 5 o'clock, if it's after 5, tomorrow morning at 8 o'clock. Okay.
Is it the one on industrial or?
It's going to be the one on 13. Can we have no
Okay.
activity on that? So we're going to go 13.
Next is Spence Phillips from the morning docket. Mr. Klein.
Judge, may I approach Madam Clerk?
Yes, sir.
Spence Phillips.
Phillips.
Your Honor, this is Mr. Phillips, 21 CF 2816. We would like to leave this set on the trial docket. I can tell the court we are in discussions with the state to try to resolve all 4 of these cases. Mr. Phillips was just asking about a bond motion, so I told him I'd come to the jail and talk to him about that. However, I talked to Mr. Gomez this morning. I believe the state would like to put this on the Thursday and Friday
Of the second week.
of the second week.
Okay. So it's a 2-day trial?
Well, it's a grand theft auto. I would have proposed a pick and go, started on Thursday. I'd hate to take Thursday afternoon off, just pick the jury, and then find ourselves here on Saturday morning.
Possibly go 2 days?
I think it could possibly go 2 days, depending on the witnesses and stuff. We're still working on, just with us, because we sent subpoenas out the Monday that we got back from pre-trial. There are still some outstanding subpoenas that we're trying to get served to make sure that certain witnesses are available. And so given that, we would just want the farthest date, which is already picked a Thursday, but just in case we do have some extra witnesses, just to have 2 days, just in case we need it.
Okay.
But I would be completely okay with doing the pick and go on Thursday, and that way if we finish Thursday, we finish. If not, we have Friday to finish up.
Okay. How many on the Venari?
Just 22.
Yeah.
Just staying together.
So, Mr. Phillips, that means that I'll see you back here no later than Thursday, June 8th at 8:30. Well, the Venari is the jury pool from which the jury is selected. So I'll see you then, and then we'll be looking at selecting the jury that morning and starting with the trial. Thank you, sir. Thank you, sir. It's only for 21 CF 2816.
That's correct. Madam Clerk, the 3 other cases, they're all bundled together, so that's the only case that's actually being tried. And it's 1 third-degree felony grand theft auto.
Next is Matthew Talley from the 130.
Thank you, ma'am.
Judge, this is Matthew Talley before the court in 22 CF 1551. Judge, we would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty, and ask for this to be set on the next available pretrial date, which is the July 10th. If we're able to reach a resolution, I'd like to be able to advance this on the docket.
Yes, sir. Does the state have an offer for Mr. Talley?
Whatever we conveyed already to.
And Mr. McKinnon, you've told Mr. Talley what that offer is?
Judge, I have a score sheet that shows 10.2 points. I do not have an offer in the file for Mr. Talley.
Mr. Talley, that was why I asked, as I looked at the charge, and I was wondering if they had an offer for you. Hate for you to sit in jail between now and July 10th if there's some offer that the state, that you may be willing to accept.
I believe that any offer from the state is going to include a restitution amount. I do not see that we have a current restitution amount, so I would anticipate that there would be some additional legwork that needs to be done before reaching a resolution.
That's correct, Your Honor.
Okay, that's the easy way out. But what if Mr. Talley decided that it was in his best interest to accept the plea and reserve on the court reserves jurisdiction to determine the amount of the restitution? Well, but he doesn't have an offer from you of what you're offering as far as probation for how long. Mr. Talley, I'm holding their feet to the fire. I'm doing it intentionally because of what the charge is. If it was something more than that and I thought the state's going to offer you some prison sentence, I'd say, I'll see you on July 10th.
His score sheet does reflect no prior record that's on the score sheet.
And I apologize, Ms. Davis, but I just want the best for Mr. Talley.
Judge, part of the problem, this is something that has been outstanding since last July. So he had to be brought back in a transport because I think he had another case going on. So that's where we're just getting him back before the court and trying to reestablish getting in contact with the victim and everything.
Okay. Okay, now that, I understand, Mr. Talley, as far as the victim, because the victim has rights too. Mr. Talley, I'll see you back here no later than July 10th, but Mr. McKinney stated, and I'll stand with him, that if you want to enter a plea, if the state offers you something next week, Mr. McKinney can get you in front of me next week and we can talk about accepting that plea, or any time after that, just about any time, okay? Thank you, sir. Allison, who's next?
I believe it's Nicholas Schneider.
Which time?
Should be on the 1:30.
1:30.
I am on the 1:30 docket now.
Thank you, ma'am.
The charge in this case of felony, petty theft and murder. Just in retail, which is understand. They know that too. Everybody knows that. They've already got to go through this list with the felony. They're also in concurrent probation of what you've already got to do. So I'm telling you, this should be the room. If we have this clear. Yes, of course.
Judge, Mr. Schneider is before the court in 23 CF 870. And the discussion relates to, he is currently on probation for another case. And the state's offer, if Mr. Schneider were to enter a plea of no contest as charged, would be for an adjudication of guilt. He's previously been adjudicated, placed on a period of probation for 24 months. That would be concurrent with the probation that he is already on. Pay restitution in the amount of $16.90 to Walmart. Pay standard court cost of $515, $150 public defender fee, 24 hours of community service work, not to trespass at any Walmart or Walmarts. There is a cost of investigation in the amount of $355.81 payable to the Niceville Police Department. And the state is asking that he complete an anti-theft course. I believe Ms. Davis has a shoplifter's awareness course that's indicated on the plea form. And those terms will be concurrent with the probation that he is currently on.
Okay, so is it both an anti-theft and a shoplifter's awareness?
Just the shoplifter's awareness.
Okay, and when you say, so shoplifter's awareness course, if Mr. Schneider has that as a term of his other supervision, he only has to do it once?
Correct.
Okay. Mr. Schneider, if you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Schneider, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
I do, sir.
Do you understand what the terms of the sentence will be?
Yes, sir.
Do you have any questions for me or Mr. McKinney or the state?
No, Your Honor.
Mr. Schneider, I do accept your plea. You're adjudicated guilty. You're sentenced to 24 months probation. That's to run concurrently, run at the same time at any other probation that you're on now. You'll need to pay restitution of $16.90 to Walmart. Have no trespassing at any Walmart. You need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, perform 24 hours of community service work, cost of investigation, $355.81, and complete the shoplifter's awareness course, the shoplifter's awareness course, and 24 hours community service work. Those are also concurrent with any other probation that you're on. Okay.
Yes, Your Honor.
Thank you, Mr. Schneider. Good luck to you, sir. The misdemeanor, is it time served?
Yes, Judge.
Yes, Judge.
Next is Shirley Phillips. 1:30.
Florence.
Hi, how are you?
Good, how are you?
This is Ms. Phillips in 23 CF 602. I talked with Mr. Gomez. There is a one-count information for felony petty theft. The state is offering Ms. Phillips, if she wanted to enter a no contest plea today, the state would agree to credit for time served, $615 in court costs, $150 in public defender fees. And she has previously been adjudicated, and Ms. Phillips would like to take that offer.
Ms. Phillips, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Phillips, do you understand what the offer is from the state?
Yes, sir.
Do you have any questions for me or Mr. Klein to the state?
No.
Do you understand that you're waiving your right to a trial by jury?
Yes, sir.
Ms. Phillips, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. Excuse me. You'll need to pay the court costs and the $150 public defender's fee. How long will you need to pay those amounts?
How much was it?
It's going to be about $765. You want me to ask? Do you want me to ask?
Do community service if I can't?
You can work off any allowable costs, yes ma'am, by community service. And if you fail to pay those amounts within 1 year from today, then they'll go to a civil lien or judgment. Okay. Thank you, ma'am. Good luck to you.
Okay. Thank you, sir.
Next is David Lanier.
Mm-hmm.
This is Mr. Lanier, Your Honor, 23 CF 884. We will acknowledge receipt of a 4-count information, waive its formal reading, enter a not guilty plea on all counts. I would ask the court to leave Mr. Lanier on the July 12th or July 10th docket.
Okay. Mr. Lanier, I'll see you back here on July 10th. Thank you, sir.
Next is Tom Megan.
Mr. Winn. This is 22 CF 2720.
Mr. Winn has 2 cases, and I just wanted to make sure that. Okay. We've got 22 CF 2720.
Yes, sir.
And 23 CF 986. In the 2720 case, Your Honor, there is 1 count of possession of a controlled substance information. In the 986 case is not, there's been no information filed on that. Because there's no information in the 23 CF 986, I don't believe we're going to be able to resolve these cases today. So in the 2720 case, Mr. Winn would be entering a not guilty plea, waive the formal reading. And I was just advising Mr. Winn, we will try to get the information filed in the other case and see if we can get this back before the court sometime in the month of June. But as of right now, we'll just have to leave it on the July 10th docket.
Okay. Mr. Winn, I'll see you back here no later than July 10th. But if the state files an information and offers you a plea agreement that you want to accept, Mr. Kleins can get you before the court in the next week, next few weeks. So I'll see you then.
Thank you, sir. The charge in the old case. Okay.
Next is Douglas Polson.
Your Honor, this is Douglas Polson and 23 CF 878, who will acknowledge receipt of a 4-count information, waive the formal reading, enter a not guilty plea. Ask that this remains set on the July 10th docket. I would, since Mr. Polson is here, just notify the state in 23 CF 911 and 23 CF 920. Mr. Paulson's 40 days expires on May 30th, and there's been no information filed in those cases. So
should have been, that was one of the ones that I didn't do.
the one, okay, I just wanted to make sure that was notified of. But I believe the court's going to see Mr. Paulson back here sometime in the month of June on another plea day docket. But as of right now, for this 878 case, we just entered not guilty plea.
Okay, we don't have another plea day, well, arraignment day. Okay, yes, sir.
Still filed with only charged in this one case. This is the, yeah, okay. But you could probably be back here in the month of June. I'll come down to the jail.
Mr. Polson, I'll see you no later than July 10th, but it sounds like I'll see you in an arraignment date before that. Thank you.
And last from the morning docket, Wendell Wright.
Thank you. Go again, Mr. Wright.
Judge, when Mr. Wright went out of the courtroom, I have been discussing the case with the state, trying to get the score sheet accurate. I thank the state for doing that work here in the courtroom. May I have a moment, Mr. Wright?
Yes, sir.
Judge, Mr. Wright, to make the record clear, is here in 21 CF 1776, 21 CF 1772, 20 CF 3187, and 20 CF 2804. It is the 21 CF 1776 case, which is currently set for trial. There have been discussions in the courtroom here today. Mr. Wright was seeking to accept the state's offer that had previously been revoked. The state's position, and I will not speak for the state here, but I believe that the offer remains revoked. And related to Mr. Wright, that leaves Mr. Wright in a position where he has to elect to either go forward with a jury trial in 21 CF 1776 or the agreement with the state at this point, and only agreement would be that if he were to enter a plea as charged, then the state would elect not to serve or seek PRR sentencing at a sentencing hearing if Mr. Wright were to enter a plea to the court.
Okay. So is there something, you're just saying that's what the offer is from the state?
The only offer from the state would be effectively to not seek PRR if Mr. Wright were to enter an open plea to the court. I guess that's the better way to put it.
Okay.
Mr. Wright would, and sorry, Your Honor, I did not mean to interrupt you. Just to clarify, the state would still be open to seeking habitual felony offender sentencing, but that would not change the guidelines. So the guidelines would remain by the state's calculations as of today, 85.05 months.
Your Honor, can I say something?
Yes, sir.
I know. My lawyer was not here Monday. I saw Mr. Klein about the 5-year offer. I waited for a motion of discovery. Mr. Klein actually gave me a copy of motion of discovery on this case. Mr. McKinney came to see me yesterday, and it was my impression that 5 years was still on the table due to the fact that he wasn't here. Mr. Klein got me a continuance till today. I got my motion of discovery for the first time. I've been incarcerated for almost 24 months, and I got my motion of discovery for the first time today. Mr. Klein brought it to me Monday in court on this case, the one case we're trying to go to trial on. I'm asking the state, please, this is my life. I asked this court for help, rehabilitation, mental health. I understand this, the deal's been on the table, I get that. I've been fighting for my life. I'm over 40 years old, I've been to prison, you know what I'm saying? I'm not trying to go back the rest of my life in prison, but you give me 10, you might give me 20, it's just, I'm asking for some type of help here. If it's the 5 years you want, this lady, Miss Sadler, I don't know if she's been fighting this case a while, but I really have been in the blind about this case for a lot of things, because everything that led up to this case is a difficult situation. And there's a lot of innocence in it, but I also am a man and I take responsibility for my actions.
Mr. Wright, let me tell you what the court can do and can't do. And you say you're looking for the court's help. The law doesn't allow me to say, Mr. Wright, I offer you this plea agreement. The separation of powers between the executive branch and the judicial branch doesn't allow me to do that. I can't make the state resurrect an old offer. Even if they would have said, we're going to hold it open to today, there's a case that says the court can't make them say, nope, you still have to hold it open. They're totally in control of their offer.
I understand that.
Judge, just so that way we're all clear here, the state on this particular case, the offer has been open for months. This has been a long time that we left it open, all the way through an evaluation with Mr. McKinney and his clients with some potential mental health mitigation. We have left it open for a very long time. This was something that Mr. McKinney had approached me many, many months ago. I reviewed it. I agreed to the resolution. We left it open and open and open. We had told Mr. Wright at a previous court date more than a month ago that this was a very short leash, that this was about to expire. We even left it open for longer than we had anticipated, trying to give Mr. Wright plenty of opportunity to accept it. The other case that Mr. Wright is referencing, that the state agreed to resurrecting the offer today, was something that had been agreed in a very short time period, not the many months that we're talking about for Mr. Wright's particular case. So at this point, the state is not going to reinstate the offer.
So is there any offer, is the only offer to Mr. Wright from the state at this point, if he pleads today, it would be a plea straight up and the state would not seek PRR?
That's correct.
So, Mr. Wright, do you understand what the downside is to a prison releasee reoffender?
Never going home, Your Honor. That's what the downside is. Never going home, so.
I just want to make sure that you understand the difference. Okay. So we're going to trial on June 6th and 7th. on 21 CF 1776. Mr. Wright, I'll see you then. Anything else for this morning?
Your Honor, I have Justin Price, this is the plea with misdemeanor approach.
Yes, sir. Thank you. Thank you, sir. Anything else for this morning? So here's what.
Nope. Okay.
I found written pleas not guilty for all those.
Okay.
You want to do other ones on the 130?
Judge, I filed a written plea not guilty for a number of folks on the 130 docket who are inmates. They're present in the courthouse, but I've already filed written pleas of not guilty if we wanted to announce those case numbers.
Okay.
They're not upstairs.
Okay.
Madam Clerk.
Do you want them up here? Or do
No.
you just want them to be, okay.
Madam Clerk, that would be Victor Robinson in 23 CF 888. We filed a written plea of not guilty. Joshua Rouege, I'm assuming that's Rue, 23 CF 893. Benjamin Smith, 23 CF 858. Lucas Stevens in 2 cases, 23 CF 829, 23 CF 848. And Michael Tennis, 22 CF 2555.
Mr. McKinney, when did you file the not guilty?
My office filed them yesterday after seeing that an information had been filed.
Okay. I know it's short timing, but if there's any way your office can let the jail know that they don't need to transport those folks.
We thought to let the jail know at 7:30 this morning when I got back to the office, but that's something that was happening while I was at the jail.
Yes, sir. Okay. Good, thank you.
One left on this morning's docket. Shirley Phillips and Williams.
Your Honor, I believe that a misdemeanor agreement of censure should have been filed. However, if it was not, I do have that copy of that.
Yes, sir. Great. Thank you, sir.
He is here, he's downstairs. If you want to take a 5-minute break or something, I can get brought up.
Or we just, is there any other inmate at 1:30?
No, well, we have one being transported from Washington County, Wingate.
He's gonna be here?
Yeah.
Oh, sweet.
So,
That's fine.
I mean, I can bring them up, actually, that works, because then they'll be done within a period.
That'll be a quick denial. and then we'll be back out.
Right now.
Okay, so what I've got is, got a judge trial in Scott on Tuesday, May 23rd. Got a 1-day jury trial on Thursday, May 25th in Stovall. Then on June 5th, I've got 2 jury trials, Rogers and Thomas. On Tuesday the 6th, I've got Wright. Wright also is for June 7th. And then on June 8th and June 9th, I've got Phillips. Is that accurate?
I believe so.
I'm sorry, Your Honor, I thought you said for Phillips, it was 7th to the 9th.
Yeah, that was Thursday, Friday.
Yes.
That was Thursday, Friday, Your Honor, of that second week.
Should have, she's scheduled for Monday, we've got,
Okay, wait, okay, so what you're talking about the week of June 5th?
right, the week of June 5th, we'll have the 2 scheduled, and then.
On June 5th, and then the 6th, you've got Wright?
6th and 7th is Wright, and then 8th and 9th is Spence Phillips.
Okay. Good. So we're just waiting for the one inmate to come up. That's going to be a denial of probation. If you want to leave and come back, you certainly can.
Okay,
Thank you.
Judge, this is Mr. Joshua Rod before the court in 19 CF 1817. He was also on the arraignment docket, and I am in plea of not guilty for him in that case number. He is being evaluated for Phoenix House in Keaton, just to see if he is appropriate for those programs. We're going to enter a denial and ask for this case to run with his new law offense on the 10th of July.
Okay. I'll see you back here no later than July 10th. If Phoenix House or one of those programs offers you something that you want to accept, then Mr. McKinney can set that hearing for next week, a few weeks from now, and I'll see you then, but no later than July 10th. Thank you, sir. Okay, we're in recess until 1:30. Thank you.